We continue with new types of trademark, the examination of formal requirements and the grounds of refusal for new types of trademark which maybe are slightly novel, maybe you have not seen before. The first thing that's going to be very important with this is going to be the representation of the mark. What I'm going to do here is to take you through a few of the steps that EUIPO have gone through recently to show exactly the way that we're looking at these new types of trademark and the changes that have been gone through before going through to examples, looking at examples which will have been examined not only for formalities, but also for absolute grounds. The representation of the mark in these cases is obviously going to be the most important thing. So at EUIPO, with the legal reform, which happened in October 2018, the requirement of graphical representation was abolished, which means that we no longer have to have this, and signs can be represented in any appropriate form using generally available technology. This is very important indeed because it means that it opened up the possibility of representing marks with different file formats. However, of course, what we mustn't forget is that the representation has to be clear, precise, self-contained, easily accessible, intelligible, durable, and objective. These are obviously things which were necessary before because we always need to be able to actually see the mark. But once we go back to the idea that this is available on generally available technology, obviously it widens it up and means that we can actually use different ways of actually looking at it. This actually creates a slightly different way that we can actually think about the representation of the mark and the way that it actually works. So for the sake of clarity and legal certainty, our new implementing regulation determines the relationship between these three elements, the representation, the type of trademark, and the description. And they give you a clear sort of what you see is what you get system, giving the representation of the sign a clear primacy over the two other elements. This means that the representation is the most important thing. In the law, it actually expressly provides for the fact that, first of all, the representation it is the representation which defines the subject matter of the registration, and that in cases that it's allowed, a description must correspond to the representation but cannot extend its scope. And the type of mark, as indicated in the application, must accord with the representation itself. These are three very important things indeed that we need to take into account. Now, at EUIPO, we've actually distinguished the different types of mark, and in some cases, we don't actually allow a description. So here what we have are the different types of trademark, whether we allow a description or not, and also the different formats that we allow. So as you can see, there are a large number of different types of mark, and only in some cases do we actually allow a description. This is actually a change because beforehand we may have actually allowed this, but nowadays these are the ones that we actually allow. A description is actually obligatory for none of the different types of marks. It's optional for position marks, pattern marks, color combination marks, motion marks, and other types of marks. This is very important indeed because it means that the description doesn't actually have to be put at all, but it goes back to what I was saying before about the importance of the representation and how the representation will actually take precedence over the description itself and over the type of mark, although of course it actually has to accord for both of those. So what's considerably changed here is the format of representing, so the different file formats, and this is mainly due to the abolishment of the graphical representation requirement. So what exactly is new here? We've got a new type of mark. So first of all, we'll start with this. One of the new mark is a position mark. This is a separate category of mark. Its disclaimed part has to be indicated by visual means, preferably by broken or dotted lines, and the description is optional. The example that we've got here is this. This is a position mark. We can see that the position itself is the gold elements which are there. This created a little bit of a problem when we were actually looking at the formalities for it because, as was said before, normally this should actually be indicated with dotted lines. So although on a formalities ground we can actually understand this because we can see that the part that is supposed to be protected is in fact these gold elements, and we can therefore accept it on formal grounds, this has actually been refused under Article 7.1b. This is the part of the regulation which says whether a mark is distinctive or not. In this case, it wouldn't be seen distinctive. The small gold piping elements would not actually be noticed by the consumer as being a distinct visual element, and so therefore the mark has actually been refused. Another example of a position mark would be this. Here, this has obviously been applied for shoes. We can see that the representation on the formal grounds is acceptable because we have the outline of the shoe which has been made in dotted lines. So the dotted lines actually only show us what the shape of the goods would be. They don't actually show us anything but that. And it's the mark itself, the arrow, which shows us what has actually been applied for. And it is the arrow here that we would be judging for the absolute grounds. For formalities, there's not a problem. Everything is actually as it should be. And as far as absolute grounds are concerned, the arrow would actually be noticeable for the consumer. It's relatively large. Its position is very clear indeed. And so therefore this mark was actually accepted. So those are position marks. If we move on from there, another new type of mark that we have is a pattern mark. This is obvious. A pattern is basically going to be an element which is repeated and which maybe it doesn't actually have an end. Here, this is a separate category of marks, and a description is optional. An example of this would be this. This is basically just a different section of buildings. Now, if we look at the buildings, we can see that the pattern actually repeats itself. This is something that's very important indeed, because if it isn't repeated, then we wouldn't necessarily be able to understand what the pattern itself actually is from a formalities point of view. However, here we can see that the different elements are repeated at regular intervals. So the mark would actually be acceptable for formalities purposes. Additionally, given the fact that it was applied for in classes 16, 29 and 35, so it doesn't really have anything which is descriptive as far as the goods itself are concerned. It would actually be seen as being distinctive, and this was accepted as a mark. It's just a repeated pattern which would be understood as far as the goods and services are concerned. Moving on to other types of mark. We also have motion marks. This again is a separate category with an optional description, and it can be applied for in an MP4 format or as a JPEG. These are quite different. Here we have an example of one which in fact has been applied for in a slightly different way. It's been applied for in 7 representations, which is the maximum number of representations that we can have. It basically goes from one representation, and you can see the evolution as it goes from one to another, with what seems to be the letter H, which appears in the middle, although it is degraded at the beginning and at the end. So can this actually be seen as a motion? Motion marks are relatively difficult to be seen if they don't actually have anything which is particularly distinctive. However, this is an old version of it because it's actually only shown as different graphical representations. If we move on to the new file formats, then we'll see something different. They can include movement itself, but also they can include words or figurative elements or labels and things like that. So this mark, which we'll see now, was applied for hydraulic fluids, lubricants, and lubricating services. We see the mark. Here we can see how it actually goes, and the whole thing changes. And as the words come on at the end of it, we can see that it actually works as a mark itself. And we can see the movement that actually happens. This mark, of course, would be seen as being acceptable, not only as the drop of oil at the beginning seen as being as moving, but as soon as the words come on, we can see that it is most definitely distinctive, and so therefore this would be accepted. Another example of a motion mark would be this. Let's have a look. So here we can see that the element fades in and fades out. It comes and goes. This was applied for communication apparatus and instruments, and also for vehicles. Now, I think you'll agree that given the fact that it's actually just it's just a glowing light on the background, there isn't actually anything distinctive here. Would the consumer actually see this as being a mark? Would they actually understand that this is a mark in itself? I think you'll agree that the answer is no. This was refused as well under Article 7.1b on the grounds of being non-distinctive. Here's another motion mark, which we will see. This was applied for a large number of goods in Class 9, including apparatus for reproducing sound and images. Now, in this case, the only thing that happens is that the two hands just separate. And we could actually see this as maybe being the way in which the goods are operated. In any case, given the fact that it is two hands just separating, we think you'll agree that there's nothing particularly distinctive here, that a consumer wouldn't necessarily understand what the trademark is or be able to distinguish this from anything else. So this also was refused on the grounds of being non-distinctive. Another example is here. Here the motion is very clear indeed. There's no problem as far as that's concerned. And given the fact that the element itself is quite distinctive, and also the fact that it spins round on its axis, there'd be no problem in accepting this. And so this would be seen as being acceptable as a trademark, as it is very much distinctive. And here's another example. This example has actually been withdrawn, but also it's worth looking at just to see the kind of thing that we actually have applied for. This is in the same manner as the other one that we saw, a light that just comes on, it blinks on, and then after a little while, it goes off again. It doesn't really matter. This was applied for in classes 9, 35, 41, 42, and 45, but there isn't actually anything distinctive here. Again, it's just a circular light that goes on and off, and it wouldn't actually be seen as being a badge of origin. So those are motion marks. We'll move on from them and have a look at another type of mark, sound marks. Now, with sound marks, no description is possible. It can be in an MP3 or in a graphical representation. MP3, we understand this is going to be a sound file. Graphical representation would actually be the mark written down as a series of notes. That's actually relatively difficult to judge and will probably go on a case-by-case basis. It'll depend whether it can be seen as being a trademark or not. We're going to focus on the new types of mark and also on the new file formats. So here we've got an example. So here we've got two repeated sequences of 6 or 7 notes. Given the fact that there is that number of notes, it's actually memorable. The consumer would be able to remember exactly what the sound mark is and how it works. Also, to be taken into account that although it is 2 sequences of notes, the second sequence actually echoes the first sequence. So it probably actually repeats and makes the sound even more distinctive in the mind of the consumer. We'll just listen to that again. I think you'll agree that that repetition at the end does actually create a very distinctive impression indeed. And so it is actually possible to remember the trademark. Another example would be this. Here, perhaps the sounds aren't quite as distinctive, meaning the actual notes that are the actual sound of the electronic keyboard is actually relatively commonplace. However, when we listen to it, it's very distinctive indeed, because again, we've got the 2 different parts. We have a limited number of notes, and so it actually allows the consumer to remember what the mark is. We'll just quickly listen to that again so that you can hear it. Distinctive indeed. The variation adds to its distinctiveness. It's sufficiently long, but not too long, so that it might actually be forgotten. This is something that we really need to actually concentrate on and to see how we do this, meaning to see if things are too long or not long enough. So here, for example, we've got another example. This, I think you'll agree, is a little bit too much. Here, there's nothing really distinctive there. It's only really the sound of an engine. It's also very long indeed, meaning that there isn't actually a way of discerning which is the mark, whether it's actually a whole mark itself. It was applied for logically in class 12, which means that there's nothing really that would distinguish this from any other kind of motor. This mark was refused under Article 7.1b because it's not actually distinctive in any way. Another example here. Now here this is very short indeed. However, as you can hear, it actually goes up quite nicely. There are two different sets of notes. And so that actually adds to the fact that it could be memorable for the consumer. However, then we get to things which are perhaps slightly more complex. This is very long indeed. There's nothing actually there that would mean that the consumer would actually be able to recognize this. There are too many parts to it, it's too complex, and it wouldn't actually be seen as being a trademark. Probably now you can't actually remember what was part of it and what wasn't, and exactly what was the logical progression that went from one part to another. This was refused because it wasn't seen as being sufficiently distinctive. Now we move on to multimedia marks. A multimedia mark is also a new type of mark. In this case, it's actually a mixture of a sound mark combined with a motion mark. In this case, there's no description that's possible. It's represented in MP4 format, and it must actually be a combination of image and sound, meaning that both of those elements actually have to be present in order for it to be considered a multimedia mark. Let's have a look at some examples of this. Here's our first one. This is applied for in class 41. I think that you can agree, given the fact that although the sound may not be terribly distinctive, that combined with the image means that it would actually create an impact on the consumer. Added to which the hat and the actual ball, which is under there, are really quite distinctive elements. So this mark was actually accepted. Another example here. Now, there are lots of different elements that are actually here, but all of those would actually be seen as being distinctive elements. This goes... And then at the end, we actually have a distinctive verbal element which appears. The whole of that goes together to be a multimedia mark which would actually be recognizable, and this was accepted. Another example of this would be the following. This is very short compared to the last one, but again we can see that the combination of the verbal element, of the figurative part that's in there, and also of the voice go together to have an element which is actually completely distinctive. More new types of mark. We also have a new type of mark, which is a hologram mark. In this case, no description is possible. Again, we can have a representation in JPEG or MP4. The thing about the hologram is that it must contain the views which are necessary to sufficiently identify the holographic effect in its entirety. Holographic effect is basically some kind of 3D effect that would be there, which probably changes. Holograms are normally produced by laser, and they actually change according to the different type of view that's there. We don't actually have too many examples of hologram marks. They're not frequently applied for. However, one example is the following. There we can see that there is actually a change in it. There is a slight holographic effect. It must be admitted that at the moment we're actually defining our practice on this as to whether we should actually accept marks which have this kind of border, whether the movement of the mark is actually there, and whether that should actually be accepted. We've actually established a common practice, or we are establishing a common practice with the other European national offices, and user associations have been involved in this. And we will be hopefully publishing this towards the end of this year, which will show the common practice for all of these new types of mark for all of the national offices for the European Union. So that's all for new types of trademark.